Welcome to the 2020 Virtual Civil False Claims Act and Key Time Enforcement Institute, sponsored by the ABA Criminal Justice Section. This session is entitled Recent Liability Developments. Before I introduce our panel, I would like to take a moment to thank our sponsors. Cone and Calipino, LLP, is a supporting sponsor for the 2020 Civil False Claims Act and Key Time Enforcement Institute. Thank you for your sponsorship. Moderating this session is Jamie Yavelberg. Jamie is a director of the Department of Justice with the Civil Fraud Section in Washington, D.C. Jamie, you may proceed with the program.
Thank you very much. First, I would like to thank the ABA and the organizers of the conference for the opportunity to participate today. As mentioned, I'm the director of the Fraud Section in the Civil Division, and I've been with the department for many years. I'm here to offer perspectives today based on my government practice, and the views that I'm sharing today are those of my own. Before I begin by introducing the other panelists, I did want to take a moment to acknowledge the passing of Jack Basie, who I'm not the first and I am sure will not be the last to mention what an icon he was in False Claims Act practice. And in addition to that, was really a very warm and a wonderful person who will be sorely missed. This conference, as many know, was his baby for many, many years, and we will no doubt hear echoes of Jack throughout the conference, not only due to the impact that he had on the law, but because of his wonderfully boisterous nature and his exuberant and easily recognizable voice and laugh, which I would say is both literally and figuratively ringing in all of our ears probably to this day. So with that, I would like to introduce the other panelists for today. First, we have Laura Hoey, who is the office managing partner at Ropes and Gray in the Chicago office, and she is a former federal prosecutor. We also have David Levis, who is a partner at O'Melveny and Myers in Washington, D.C. David was formerly an attorney with the Fraud Section in the office that I work in, and also was Chief Oversight Counsel to the House Energy and Commerce Committee. We also have Tejinder Singh joining us, who is a partner at Goldstein and Russell in Bethesda, Maryland, and he, as many know, is a very accomplished relators counsel. And we also have Karl Sloan joining us today. Karl is an assistant attorney general in the state of Washington's Attorney General's office with the Medicaid Fraud Control Unit. So with that, if we could advance to the next slide, please. So the first thing that we are going to talk about today, which should surprise no one, is materiality under the False Claims Act post-Escobar. And as many of you know, in 2016, the Supreme Court issued a decision called Escobar, in which the context of the case was mental health care allegedly being provided poorly by unlicensed individuals. And the court grappled with a legal theory called implied certification. And ultimately, what the court decided was that rather than taking a circumscribed view of what falsity means under the False Claims Act, the question really was when there was a demand for payment being made and the party failed to comply with an underlying rule, the question came down to materiality. Whether the thing that the person or entity failed to comply with was material to the government's decision to pay the claim. And now that we have had several years of practice since the Escobar decision came down, we thought it might be helpful to talk a little bit about how the law has evolved. So first, I'm going to ask David to share with the participants an overview of how the law has developed post-Escobar, particularly in the context of evaluating materiality at the pleading stage of a case.
Thanks, Jamie. And before I get to your question, I just want to note that I too am feeling the profound and loud absence of Jack Basie at this conference, and Laura and I have big shoes to fill with his absence. We can't be nearly as warm or boisterous as he would be, but hopefully we'll be genuine and provide a little bit of insight, as he surely would. It's interesting looking at the jurisprudence from Escobar in the years since the decision came out, because it's funny now to think back to the focus before the argument and before the decision on the anticipation about the question about whether implied certification would be upheld as a viable theory of liability. In truth, that was kind of a snoozer in the decision, and not at all surprising that the court upheld it. What has been most interesting about Escobar, as it's worked its way, its legacy has worked its way through the lower courts, has been the language and analysis on materiality, and it seems that the way the lower courts have interpreted it and the way litigants have used it would probably come as a surprise to the Supreme Court, in that the justices, the opinion anticipated that the materiality standard that Escobar explored and articulated and emphasized would be one that could be appropriate for resolution on a motion to dismiss. What we saw shortly after Escobar came down was that it was this shiny new toy that people tried to use. You got a lot of motions to dismiss arguing for dismissal under Escobar's materiality, and while there were some that were successful for defendants, that seems to be the outlier, and I think that will likely prove to be the outlier going forward, because it's challenging, frankly, on a motion based on the pleadings, where relators' allegations have to be taken to be true, to establish that materiality can't be proven as a matter of law. And I would think, Tejinder can speak to this more, but any relator's counsel who's not committing malpractice will not put allegations in a complaint going forward that would support a motion to dismiss based on Escobar materiality. On the other hand, it's been a game changer in terms of discovery directed at the government in order for defendants to prove a basis for defeating materiality, and it's a very viable tool at summary judgment. I would say more so at summary judgment than at trial, because materiality feels like a legal issue that, while a compelling basis to throw out a case, is probably one that has less appeal to a lay juror. But summary judgment is going to be, and has proven to be already, the place where Escobar is having its greatest impact.
Thanks, David. And it's helpful to get an overview of the where the law stands as you provided. But can you share with the group in sort of practical terms the decision-making process that a defense counsel and a client might have discussions about in whether to decide to move to dismiss a case on materiality grounds?
Sure. No, it's a great question, and it's one that we entertain frequently at the outset of a case where we see the complaint. Again, Escobar made a big impact, a big splash in terms of legal media coverage, and most sophisticated clients have at least, who operate as government contractors, have at least passing familiarity with Escobar, and will get a common question, why can't we move to dismiss? It, like any other tactical legal question, has to be answered on a case-by-case, fact-specific basis. But in general, my instinct is that a motion to dismiss on alleging materiality or basing the defense on materiality is often a mistake. Again, because of the difficulty of prevailing as a matter of law, as opposed to filing a 9B motion for failure to allege with sufficient particularity. There's an argument to be made for an early materiality argument to educate the court. The same judge who's going to be who evaluates a motion to dismiss is going to be evaluating your summary judgment motion, and to begin educating that judge about the key facts in this case and why materiality will not be established. You can take steps to do that on a motion to dismiss. On the other hand, and it's a very big other hand, there's danger in asking a judge to evaluate materiality on the motion to dismiss and losing and getting unhelpful language in that decision that you have to live with for the duration of the case, and also having a judge who has now begun to formulate an opinion about whether materiality will likely be proven on this record. In most instances, my instinct would be to avoid filing a motion to dismiss and saving materiality when there's a more complete record and the relator's pleadings don't need to be taken as true.
Okay, and so when a case moves past the pleading stage, Tejinder, can you talk a little bit about how the courts are evaluating materiality when there are factors that may cut in both directions, and how you see the role of materiality sort of changing from case to case, for example?
Sure. So the big thing to realize is that almost all of the action in materiality on the defense side is about the government's continued payments after discovering knowledge of the relator's allegations. And so there is an ongoing debate about whether knowledge of the allegations is enough to then draw an inference of immateriality, or whether the government has to have actual knowledge of violations, meaning, in other words, the defendant has admitted that they did what the relator says they did, and the government says, okay, well, we don't care. I think that you'll see that the Supreme Court said that if the government continues to pay despite actual knowledge that certain requirements are violated, that's really strong evidence that those requirements are not material. And so when that evidence is surfacing in cases, I think you'll see district courts more inclined to toss the case at summary judgment. But, when you have factors that point in the other direction, and so some of the most common ones, if you're a relator, that you're likely to point to are if there is statutory, regulatory, or contractual language saying this is a condition of payment. The Supreme Court said that's relevant but not dispositive. And I think as a relator, you're on reasonably good ground saying, well, if it's relevant, then you have one factor one way, one factor the other way, and we kind of let the jury figure this out. If it goes to the essence of the bargain, and that's a little more loosey-goosey, but of course you can find ways to articulate why a particular requirement is not ancillary, but is instead kind of at the heart of the bargain. For example, if you're talking about a range of goods or services, and the allegation is that some were just really not provided as promised, I think you've got a reasonably good argument that even if the government continued to pay, you'll have a jury question on materiality. And that can also be accomplished by kind of picking at the idea that continued payment really means something. The Supreme Court clearly thought it did, but as David says, you'll talk about this on a case-by-case basis, and there may be situations where, for reasons that are totally external, the government wants to keep paying. So, for example, if it's buying an essential product or paying for patients' care, and most of the stuff is okay, but some of the stuff is trash, the government's going to probably keep paying, right? It's really hard for the government not to pay its contracts or contractors. And so you can make arguments about the inertia as well. And I think at the summary judgment stage, that's always going to be the interplay, is for the relators, are there factors that gesture in the direction of materiality? And for the defense, is there really strong evidence that the government actually knew what was going on and just didn't care? And that is also why it's become really a summary judgment question, as opposed to a pleading question, is because relators can just, not plead the bad facts and only plead the good facts, and that gets you over the hump.
So have you encountered situations where you would argue, Tejinder, that materiality is something that is either as a matter of law established or very close to that line, circumstances where it's really not debatable from at least from the plaintiff's perspective, whether or not something is material, because that really does separate the kinds of cases where this materiality question may arise, won't it?
Absolutely. I think that it's important to bear in mind where the sort of materiality discussion Escobar came from. It came from how do we narrow implied certification liability so that the entire universe of regulatory violations doesn't lead to False Claims Act cases. And the Supreme Court said, well, just focus on the regulations that are important, the material ones. And I think the right way to think about materiality then is as potential for causation, right? If the violation of the requirement has the potential to influence the government's payment decisions, then you've got materiality. And I think, it follows from that if, as the plaintiff, you have actual causation, you should be moving for summary judgment on materiality for your side, right? And trying to do so as early as possible, precisely to kind of head off all of this discovery that David is talking about on the government that might be very burdensome, might make the government hate your case, might be distracting from what are the real issues. But even short of having actual causation on your side, I think if you've got cases that don't fall in the traditional implied certification rubric, express certification cases maybe, but also any case where you would describe the violation really as factual falsity, that's a time to take materiality off the table as early as you can as a relator and try and get a positive judgment as a matter of law.
Hey, Tejinder, if you view materiality as potential causation, doesn't that write the language out of the decision about the relevance of the government's continuing to make payments?
I don't think so, because I think that that's still relevant evidence of potential causation, right? In the absence of other evidence, looking at what the government does is, I think, a good way to figure out was there potential. But on the other hand, I think that while it is true that causation establishes materiality like a fortiori, the opposite is not true. Now, the way you do the opposite is you say lack of materiality refutes causation a fortiori. I think that's right. But I don't think that helps the defense on materiality. I think it helps them on causation, potentially. But that's just a redundant win for the defense, so I don't think it really helps you at all, actually.
So, Tejinder, can you give an example of a circumstance of a factual falsity case where you think materiality may really not be much of an issue?
Oh, sure. I mean, like all of your classic overcharging cases, right? So it could relate to like the average wholesale price of drugs. It could relate to, just like classic factual falsity, right? You have a contract where you say, we're going to give you 10 widgets for $1,000 and you only give them 8 widgets and charge them $1,000. I don't think we need to talk about whether the failure there is material. There's $200 of difference or something there, and it's actual causation. And so I think there is sometimes a mistaken thinking where people think materiality means big, but that's not quite right. Materiality just means important to payment decisions. And I think where you have a circumstance of factual falsity, like I described, or any kind of overcharging, you really ought to be saying, look, we're arguing about actual price impact, actual dollars out the door from the government for something that wasn't provided as promised, and that's material per se.
Thank you. So moving over to the question that's already been touched on, Karl, I thought maybe to provide some context to this government action question, you could share with the group how the First Circuit on remand actually grappled with the materiality question as it was remanded from the Supreme Court, and then ultimately, in particular, how the First Circuit dealt with the question of the fact that the government had not denied payment or attempted to recoup payment.
Sure. So the issue on remand was basically whether the relator sufficiently pled the False Claims Act violation, and the court found yes on remand. Materiality determination, basically the court said that the fundamental inquiry, and this has already been touched on, is whether the piece of information is sufficiently important to influence the behavior of the recipient, in this case, the government. And in this case, the defendant was asserting that the continued payment of the claims by the government, despite knowledge of the violation, was evidence of non-materiality. The court disagreed, but they also went on to say that mere awareness of the allegation concerning noncompliance is different than actual knowledge. So they kind of said, well, you can know about it, but unless it rises to actual knowledge, it's not necessarily non-material. So the court also said that they found that there was no basis in this case that the government had actual knowledge, even though there clearly was indications that they would have had knowledge about the allegations. But they also went on to say we're not deciding whether actual knowledge would even, if they had actual knowledge, whether that would be sufficiently strong evidence to support the motion to dismiss. So in this case, they basically said there wasn't. There was some knowledge, potentially some knowledge, but it wasn't enough to make the issue non-material. They also went on to say that the relators at this point of the motion to dismiss phase were not required to learn or allege the government's payment practices beyond those services that were rendered to the relator's family. So part of the reason there was because they recognized the difficulty in learning that information, at least at that early stage of the case. Ultimately, the takeaway of it was it appears that though not dispositive, even actual knowledge is not dispositive, the continued payment of the federal government or the government at the state level after they've learned of the alleged noncompliance or fraud, the longer that goes on, the substantially higher burden that the relator is going to have to establish materiality. So I'm not sure if I answered the question entirely, but ultimately they found that materiality with the knowledge of it is not, even though the government knows about it, doesn't make it non-material.
Thank you. That is very helpful to provide some context as to how a court has analyzed the question. Laura, I'm hoping that you can share with everybody your sort of practical perspective and view as to how successful this government action argument has been in the courts post-Escobar. What are the arguments that seem to be working versus maybe those that are not?
Sure. And thank you for noting that it is really a practical observation. So I'll sort of pick up where Tejinder left off, which is not the motion to dismiss stage, sort of moving forward to summary judgment. I think that from the defense perspective, the government knowledge argument has a lot of appeal for common sense reasons, which is in the False Claims Act setting, if the purported victim is the government here, right? And if that purported victim knew about the alleged fraudulent conduct or the contractual violation or the regulatory violation and continued to pay for some time, it's really powerful evidence that it wasn't material to the government's decision to pay. And so in addition to having this practical appeal, I do think it's an important safeguard or sanity check on what I think is widely held, which is that the False Claims Act is not a general fraud statute, right? It is not intended to enforce perfect compliance with every contractual obligation and every regulatory obligation. And so if with that lens and looking at some recent cases, I think I'm quoting that from Jansen in the 10th Circuit, where there a CMS investigator had looked at the allegation, which is the lack of underlying plans, and the government very wisely and rightly did not intervene in the case. Very powerful evidence that this was not material to the government's decision to continue to pay, which it did. And I think the other case I would cite too for sort of recent successes, it's a little bit of a split the baby success, but is Ruckh in the 11th Circuit, where they did distinguish between knowledge on the Medicare front and knowledge on the Medicaid front. But at the end of the day, even said for the Medicaid claims where they upheld the judgment for the defendants, that it it was nothing more than a condition to pay, which is something Tejinder, I think you're right, would probably get you past the motion to dismiss stage. But then when you're at summary judgment or there, when you've actually gone to trial, it's going to get down to the nuts and bolts, and it's going to require a heavy lift from the government to explain why the continued payments occurred. So I think that's just from the practical standpoint and my bias and view that, we've got to have some check and measure on the use of the False Claims Act as a general fraud statute.
Okay, thank you. I think we probably could debate this topic even longer, but and I'm sure Tejinder would very much like to respond, but we are nonetheless going to move on to our next topic. If we could advance to the next slide, please. We will touch for just a couple of minutes on the medical necessity and objective falsity battery of cases. There have been a number of them fairly recently. Of course, the medical necessity issue springs from the requirement in the healthcare context that the government pay only claims for services and goods that are medically necessary. And the dispute in a lot of these cases has come down to the judgment and how you measure this question of medical necessity. And there have been some creative legal arguments to try to curtail those kinds of False Claims Act cases. A number of decisions recently, which I hope Tejinder can give us an overview on, and then hopefully give us some practical sense there too in terms of how these cases might best be approached.
Sure. So, the four cases that are listed in the slide kind of fall into two buckets. Two of them, AseraCare and Druding, are really about the standard for hospice care, which is when you have a physician has to certify that in their judgment, their clinical judgment, the patient has a terminal illness. And then the other two cases, Polikoff and Winter, are really about the more classic sort of Medicare necessity requirement. Winter was about inpatient admissions. Polikoff was about heart surgeries. And, in all of these cases, what's going on is that doctors are saying, we think patients need X, right? Hospice or some procedure. And the relators are saying, no, they didn't need that. You were, that's false. And so what you've done is you've caused the government to pay out money that it shouldn't be paying out. And the action is around whether that's enough to state a false claim, right? To just say, no, that's wrong. Or whether what you need is really something more in the vein of, well, there was also something deceptive about the claim, a lie of some sort. And I think that the right way to think about this, and I think the view the government has taken, which I subscribe to wholeheartedly, is that you've got a false claim whenever you have a claim that just isn't eligible for payment, right? And so if you say a service is medically necessary, but in fact, the government would not pay for it, you've got a false claim. And I think it's important to keep separate that, the False Claims Act has two separate provisions, right? In 3729A, it has a provision against false or fraudulent claims, and also a separate provision against false records or statements that are material to false claims. And so it shouldn't be the case that you need a false statement to make out a false claim, right? Otherwise, the two sections don't really do different work. The first one is just kind of subsumed into the second. And so the right way to think about it, I think, is the government's view, which is that if you've got a claim that isn't eligible for reimbursement, you've got a false claim. And then everything else goes to scienter, was it knowingly false or recklessly false, and materiality, and not to whether it's false in the first instance. And that the best example of an opinion that basically says that is the Druding case. And then also Polikoff and Winter in their own context of medical necessity kind of makes similar arguments. AseraCare is a little bit different. There, the court says you need to have objective falsity. But the way the court defines objective falsity, it's actually quite close to what I said. All they say is that what you can't have is just a mere difference of expert opinions. But honestly, nobody is bringing a case where all they have is a mere difference of expert opinions. So it's kind of like, yeah, whatever.
Okay. One of the other things that I think has come up in this space is whether or not there should be sort of test or a different way of looking at these cases as opposed to other kinds of cases because they involve opinions. Is this an area that's particularly unique to false claims practice?
No, fraud statutes in general, securities fraud is probably the best example. The Supreme Court has this case called Omnicare, which is very good on this. It holds that opinions can be false, and they can be false when they're not actually held. They can be false when they reflect some sort of process by which the opinion was reached, which actually wasn't followed. They can be false when they, appear to betray confidence about something that isn't warranted in light of facts the opinion holder knows. There's all kinds of situations in which opinions have been deemed to be false. So I don't think we're treading new ground in the False Claims Act space. I guess I would say that, if you take seriously my point earlier that the False Claims Act, a false claim exists whenever a claim is not eligible for reimbursement, right? Then whether the criteria for reimbursement is based on an opinion or on a statement of fact doesn't really matter at all, right? You're still just skipping ahead to the ultimate question. But even if you were trying to apply like the common law or the law of fraud more generally, I think it's pretty well settled that there are a variety of contexts in which opinions are going to be false.
And I think it's worth adding to that point, Tejinder, thank you, that, juries have historically been able to make these kinds of determinations across the board in a very wide variety of cases, including criminal cases. And so if juries are permitted to make these kinds of judgments in criminal cases, then it really does seem strange to suggest that for some reason these kinds of questions can also be answered by juries in Civil False Claims Act cases. And I think the other point that you made, which bears some underscoring here, is that to the extent that people are worried about second guessing or the sort of a little bit of a Chicken Little effect here, there is, of course, a scienter requirement in the False Claims Act. And so good faith beliefs are going to be protected. And the plaintiff in these cases, the government or the relator, is still going to have to show and satisfy the scienter element of the False Claims Act. And that, I think, is a pretty powerful argument for why, once again, the question of whether or not a claim is false is really the wrong, and curtailing that is the wrong instinct when you're concerned about an expansive view of the False Claims Act. So now I'd like to jump to a new topic, kickbacks in the False Claims Act, which, of course, False Claims Act cases may be predicated on underlying violations of the anti-kickback statute, a federal crime. And of course, kickbacks involve remuneration, direct or indirect, to induce the referral of goods or services that are paid for by federal healthcare programs. False Claims Act cases involving kickbacks has been a robust part of False Claims Act practice for many, many years. There is no reason to think that it will not continue to be an area where the government focuses and where there are continue to be many cases. One thing that is interesting is there, of course, have been a number of fairly significant recent kickback cases, and the Office of Inspector General for HHS recently issued a special fraud alert dealing specifically with kickbacks. So I thought, Laura, maybe you can share with us some information about recent cases and then also do a little bit of a dive into what that special fraud alert was about and the ways that you think it may change or not change existing kickback practice.
Sure. Thank you. I actually was going to dive right into Novartis and speaker programs, but I want to make one quick note because of a case that came out earlier this week in the Northern District of Illinois, which relates to nurse ambassadors. So there was a little bit of or white coat marketing, right, however you want to refer to it, but there was a little bit of a flare on those cases. Last year, there were the Eastern District of Texas cases that were Gilead and Lilly and Bayer, and then AbbVie sort of got caught up with the California Insurance Commissioner getting in on the action, and that case was resolved. But the case that was just decided at the district court level in the Northern District of Illinois is Suarez versus AbbVie. There's overlap in the underlying allegations, but I flag it because while I thought it had sort of died down with the resolution of those cases, I think it's a really critically important policy issue, especially in the provision of care, where when is the line crossed that a person who's a medical professional does more than provide product support. And so there's some interesting commentary in that case, so I'd encourage people to read it if you're interested in this allegation about what kind of advice or what kind of counseling goes beyond product support. And I find it a little bit troubling because I think it invites, for example, if someone calls and says, is this a side effect of the drug? And the answer is no, but it could be a side effect of something else. That seemed as sort of invading the provenance of the physician's office and therefore providing support to the physician's office that arguably could violate the kickback statute. So I encourage folks to look at that. But as to the core of your question, and I think speaker programs are front and center in part because of Novartis, but also because of the recent fraud alert. And I think what's interesting if we look at those together is that when Novartis came out, right, and it was huge dollars, it was out of the Southern District of New York, $729 million, is at least in my circles, I think folks looked back and thought, wow, this is really old conduct, right? It goes back to 2011, and no company in their right mind is going to be hosting a program at Hooters, right? So like that one just jumps out. It's like that's obviously inappropriate, and companies have learned their lesson, and they're never going to go back to that way. So in some ways, I think some folks were dismissive of Novartis and what the takeaway should be, and I sort of see the fraud alert, while not issuing anything necessarily, as a sea change, as a little bit of an exclamation point on Novartis, on saying, no, well, actually, here are the things in Novartis and the very strict CIA that came out of that we want you to take extra, we, the government, want you to take extra note of. And I guess what concerned me about the fraud alert is, one, there's no mention of the personal services safe harbor, which I assume is still strong and applicable. And I think that while the fraud alert did contain the language that said, look, no factor alone is going to carry the day, right? And it's multifactorial and we look at everything, but here's what we want you to consider. I think there were a couple of things that really fly in the face of industry standards. So the absolutely no alcohol mandate, that is somehow not conducive at all to an educational environment. I don't think that's the policy. I see Tejinder laughing. I know you want to go off mute. I know how badly you want to jump in here. Look, my point is if you're telling me someone can't have a glass of wine, maybe not hugely expensive wine, and also listen and absorb that, then we have a problem, right? Because I'm not sure that's how it exactly works. But my point, I'll make it one that's probably less controversial. I think is less controversial, which is the restriction on someone going twice or more than once to any particular topic where the substance might be similar. I can think of a lot of legitimate reasons why that might happen. One of which is if someone's going to be a speaker and they say, hey, so-and-so is really good in delivery and content, and you should go observe them, right? Clear, there's two. So I'm always sort of bothered by hard and fast black and white rules in fraud alerts. But I do say in credit to OIG, this was a please do not be dismissive and give Novartis the back of the hand. Pay attention because speaker programs are front and center. And here's the lens that we're looking at them through.
Thank you, Laura. Can we advance the slide, please, to kickbacks? I see that. Thank you very much. So Karl, from the state perspective, can you share with us whether or not you see any kind of stepped up enforcement in the kickback area, or just more generally the way the states deal with this kind of conduct?
Sure. There will be likely, if the emphasis at the federal level is on kickback cases, that will drive some of the state activity because of the close connection on the KETAM cases that are brought at the federal level where the states are named, so they're party to the cases. So we're going to see any increase there translating into the states. As far as kickback cases, we do investigate kickback cases. We expect that would continue. They're very fact dependent and always present in the types of cases we get at the state level only as clean kickback cases. Oftentimes, those are dependent on a whistleblower or maybe a co-defendant presenting that evidence to us. So it may not be obvious at the outset. In some cases, such as overprescribing cases, where we're doing data analysis of the prescribing behaviors, there may be evidence that is developed from that leads us to information about kickbacks that were going on, and we've seen that in the past. So ideally, we would see an uptick if that emphasis at the federal level is on kickback cases. And at the state level, obviously, that is something we're going to be aware of and looking for. It's just the question of whether they'll present themselves, obviously, as a kind of a straight kickback case like Novartis, or whether it's more developed later in a case that is initially started on some other allegation.
Thank you, Karl. David, I'm sure you're familiar with the special fraud alert issued by OIG as well. What kinds of advice are you giving your clients who may have seen this and been worried about whether there's something new here that they needed to be worried about?
Well, I guess I'll start by echoing Laura's view. I think we in the white-collar bar can reach a consensus in advising our clients not to have business functions at Hooters. You can get great wings elsewhere. And from a compliance perspective, it's probably not best practices. In terms of the fraud alert itself, I am a fan of bright line rules, even when they're, conservative and perhaps a bit out of touch with business practices, because I think they at least give greater clarity to businesses about where they're going to run afoul. My view is that that OIG is sending an enforcement message in terms of its priorities when it releases an alert like this. The substance of it may not be groundbreaking in terms of the standards that they're applying to compliance, but it sure clears the mind and gets the attention. And my advice to clients is that they're not putting an alert like this out by accident. That they are devoting resources to further enforcement efforts in this space, and to the extent that most good companies are not revising and reinforcing their compliance simply based on the risk of stepped up enforcement, but you have to pay attention. And where there are holes and areas of improvement, you're best off starting with areas where the OIG has said, we really do care about this, and these are rules we want you to follow.
Okay, thank you. Good advice. Let's advance to the next slide, please. So now we're going to talk a little bit about government dismissals, an area that in some respects may get some outsized discussion and importance because the legal issues are very interesting. It's an existential threat potentially to from a relator's perspective to a quitan case. But in practice, of course, in the grand scheme of things, given that the government sees hundreds and hundreds of cases every year and only a very small fraction of them does this issue really arise, arguably it's a lot of talk for a small number of cases. But because it's an area that has generated a number of cases in the circuit courts recently, and it is legally a very interesting area to those of us on the panel for sure, we wanted to take a couple of minutes to update folks on what the lay of the land looks like for this kind of question. And I'll ask Tejinder to start us off with sharing what the different standards are and what is sort of percolating right now in the circuit courts that people should be thinking about.
Sure. There are kind of, again, two aspects to this that are being hashed out. There's a procedural aspect, and then there's the substantive standard governance. On the procedural side, there's a question about whether and when the government can move to dismiss. And prior to very recently, the consensus view in all the courts was the government can just kind of do this whenever it wants. The Seventh Circuit recently issued a decision that said actually the government has to intervene first, and then said, when they can intervene and when they can move to dismiss is kind of governed by the federal rules of civil procedure, and that's how it should work going forward. And they also said we'll treat the government's motion to dismiss also as a motion to intervene, and we'll grant it in this case. The Third Circuit just heard oral argument in a case that raises the same question, where the relator is taking the more aggressive position that after the government declines to intervene in the first instance, it can't come back and intervene to dismiss the case. The government's hands are tied from that point forward. I filed an amicus brief arguing for kind of the middle ground position, which is the government can intervene, but it has to have good cause to intervene, an explanation for why it didn't do so before. That's all being hashed out in the courts kind of in real time, and I think is super interesting. Then there is the question of the substantive standard, and this is the place where I think, although there is technically a circuit split, it's not much of one. So there are a couple of courts that say the government has unfettered discretion to dismiss a case. And there are a couple of courts that say that the standard is sort of this due process-y standard whereby the government has to have some kind of rational explanation for what it's doing. And, that's been applied, I believe, a couple of times to say, well, this dismissal was improper, but usually the government's going to be okay there. I think the government's practice has been to argue under the more restrictive standard that dismissal is okay, even as it also argues that it has unfettered discretion. And I think that generally has been pretty well received by the courts, and courts are giving the government a lot of latitude on the substantive side. So I think more of the action is going to be in these late-breaking procedural posture cases.
And so, David, from sort of a practical impact, this question of government intervention in order to seek dismissal of the case, how do you see that playing out, for example, if we do have another circuit joining the Seventh in adopting that kind of a requirement? How do you I mean, it's hard to predict. Nobody has a crystal ball. But what do you see the practical impact, and how do you see it maybe playing out?
Sure. Well, we in the defense bar are eagerly anticipating the Yavelberg memorandum to update the Granston memorandum on this issue. But until we get that guidance, I'll just speculate. I think this is an area where Congress is ultimately going to have to clarify the intent. I mean, I think, not surprisingly, that the statutory language suggests that DOJ should have pretty unlimited discretion for dismissal, and that the courts that are finding otherwise are just getting it wrong. That where the government is the real party in interest, there's no indication that Congress ever wanted to empower a relator to be able to proceed with a case over the objections of the government at any stage. So I do think that this is unlikely to be resolved without either the Supreme Court weighing in or Congress, and perhaps both. So I look forward to more legislative guidance on what this really means.
So moving on from some of the legal questions surrounding the dismissal provision of the False Claims Act, no matter what the standard is and how the courts ultimately rule on this, David, how do you counsel your client on whether and when to ask the government to consider dismissal of a case? Surely it's not every declined case you see, or perhaps it is. And if you could share with us that kind of decision-making process.
Sure. Yeah, it's a great question, and it's challenging because as with the coverage of Escobar, when the Granston memo was released or disclosed, there was a lot of coverage about it, and there's been a lot of attention among companies in this space who believe that their case, when they're sued in a declined case, that it should be a good candidate for a discretionary dismissal. And so it's no exaggeration to say that virtually every client who learns that they're subject to a qui tam wants to know, okay, when is the right time to approach the government and ask for a dismissal? And that can involve some, sensitive, difficult conversations, because not every case is really ripe for dismissal. And even for cases that are, there are moments when it makes sense to do so, and others when it might be premature. It takes a long time through DOJ's investigation and sometimes even into discovery to really flesh out the weaknesses in allegations in some cases, and also the risks to the government of allowing the relator to proceed. So sometimes, my role is to help persuade a client that, yeah, we might have a good case for dismissal, but we don't want to go right in the door, the second after we've gotten a request from DOJ for cooperation to say, here are all the reasons why it should be dismissed, because I sort of feel like you get one bite at that apple. And for credibility's sake, you want to make sure that you're making your best case possible.
And Karl, can you talk with us a little bit about how whether states have policies or practices regarding dismissals of quittams under various state laws, and maybe share with us your view about whether states exercise this authority? And I think people will be interested to hear about the way the states view this question. Sure.
As far as having a policy like the Granson type memo or policy, I'm not aware that individual states have that type of formal policy on dismissals. Presumably there'd be internal policies used in evaluating whether a case should be dismissed, what's appropriate to dismiss. Many of the state False Claims Act, or most of the state's False Claims Act statutes track with the federal statute, so it would be similar in terms of consideration. The states, as far as exercising dismissal and in what circumstances, some states do move for dismissal. The considerations in regard to that would be presumably similar to what the federal government would look at, which would be problematic cases, issues of agency burden or resource strains, legal issues with a case, proof issues, parasitic relator issues, and other types of kind of the commonly raised matters or issues that would warrant a dismissal. It's not common, and oftentimes it would come up in the context perhaps of a case that involves both the federal and state governments, where the DOJ would ask the state to join in a motion to dismiss at the federal level. But at the state level, it's not going to be, at least it hasn't been, common.
Thank you. And of course, from the federal government perspective, it's an important tool that is judiciously used, which I think is sort of along the lines of what you're saying. The question that I think we get a lot from the federal government side is a little bit more of a process one, in terms of, okay, there's a case that the government's declined. How does the government evaluate those kinds of dismissal questions? And of course, there is guidance in the Justice Manual about the kinds of things that the government will take into account. But there's just sort of process questions that I thought it might be helpful to share a little bit, because it's a question that I think people do tend to ask us a fair amount. So, like, who do you confer with, and what do you talk about, and how does this work? And I think that the best answer is that this is really very case specific, and that the government really does attempt to be very open with both of the parties in these discussions. When the government declines to proceed with a case, it really does strive to share a lot of information with relators and relators counsel about its thought process. It may be because a violation is not material, but it may also be because the evidence just didn't bear it out. Sometimes it'll be because of the legal theory. There could be a whole host of reasons, and we try to identify those obstacles for relators counsel. And then ultimately, when the decision is being debated about what to do, that can emanate from the Washington, D.C. attorney. It can emanate from the U.S. Attorney's Office. It can come from the agency. And sometimes it does come from defense counsel like David or Laura, who would like the government to consider that kinds of question. And one thing that I think is useful to underscore here that I'm somewhat surprised is overlooked is that what the agency's view is matters quite a bit to this decision-making process. Ultimately, it's their program, and ultimately they're the ones that are making the payment decision. And so we do consult with the agency about these kinds of questions. It's not a matter that is just solely committed to the department because it's in the Justice Manual. We have a client, and we do consult with them on this. And I think that's an important thing for folks to keep in mind. our practice is generally to talk with both sides and to give both the defense and a relator's counsel an opportunity to really share their views on this question and whether or not a case is appropriate for dismissal. I think what might be useful for folks to hear about is from Tejinder, when you are sort of faced with this situation where you've got a declined case and maybe you're rolling your sleeves up and starting to move along, and then the government comes knocking and says, hey, we're thinking about this. What is a good way for a relator's counsel to try to navigate that kind of issue? What kind of advice would you give to your fellow relators counsel here today?
In that circumstance. Other than that, I think the right thing to do is to realize that if the government wants the case dismissed, it's probably going to be dismissed. And so your number one objective at this point is to try and get the government toward a more palatable outcome. In my experience, the more palatable outcome that is achievable, usually, once the government has gone far enough along to tell you, like, we're thinking hard about dismissing your case, is to see if the case can be steered toward a settlement. Now, you kind of hope in this circumstance that the defense doesn't already know that the government is probably going to dismiss the case, because you have very little leverage if they do. But assuming that they don't know, you can start to have a conversation about maneuvering the case, and if you have receptive folks in the government, that can sometimes work out. If that's not if it's not yet time to think about that, then the advice I would give is that it is, because, as Jamie says, it is so case by case why the government will dismiss. You really want to see if you can drill down on those reasons and provide as much substantive reassurance to the government about whatever their concerns are. And so, arguments that I've heard about the government making that were sort of points of concern, or, just as a policy matter, we kind of disagree with how this case works. Well, it's very hard to push them off that, right? If an agency is telling them that, then that's what it is, and you just kind of want to say, like, can we get to settlement? Because then we won't be messing with your policy. It'll just kind of go away. Other arguments, though, are like, we're worried this case will make bad law. And in that case, you might want to find someone who's nerdy about the law to come and help you make a pitch to the government that actually it's all going to be okay. If the concern is really like, we're worried about the discovery burdens, then you might want to come up with a plan for how you think the discovery can be rendered more manageable, and steps you can take that will alleviate the government's discovery burden, to the extent you have the ability to help pay for things. Maybe that will assuage them. There's things you can think about. But I think the most important point is be attuned to what the government is concerned about, and think as hard and creatively as you can about ways to give them what they want without scuttling your case.
Okay, thank you. So I'd like to move along to the next slide, please, and the next topic that we thought we would try to touch on today. Of course, the pandemic has affected the country and the world in many, many ways. And for those of us that practice in government False Claims Act and fraud cases, we are particularly attuned because of the ability to potentially exploit the healthcare system in a time of crisis, and also because of the massive amount of stimulus funds that Congress has authorized that a number of federal program agencies are administering and sending out, literally trillions of dollars. So I thought maybe to start with, I'd ask Karl to talk a little bit about whether you're seeing or what kinds of expectations you have about the kinds of cases that might be trying to, or the kinds of fraud schemes that may be coming up or taking advantage of a situation when the healthcare system is particularly vulnerable.
Sure. What we would expect to see, again, is the cases, for example, the misuse of the CARES Act funds. There are parameters on the appropriate use of those funds, and clearly that's going to be an area open to fraud where there's not a significant amount of oversight. Other areas that we may see percolating through and are seeing some signs of that would be, especially in care facilities, issues of worthless services or care, where basically the care was so substandard or non-compliant that that really it amounts to worthless services. Related to that, since we do also do criminal cases, we would likely expect to see an increase in abuse and neglect type of cases as well. Some other areas that we could expect to see are medical lab and testing cases being problematic, and potentially issues related to prescription cases where there's some relaxation of the visits and use of telemedicine in prescribing. So we could expect to see some changes or some cases coming through with that. But it's the other factor that kind of works into this, and I'm not sure how that will shape up as far as the push for liability limitations and whether those will be applicable to any of the False Claims Act types of cases or whether those will be excluded. Several states have put in place liability limitations. It's clearly a matter that's a hot topic with any future bills that are coming through to provide relief. Some states have exempted False Claims Acts from that limited liability activity, but it's arguably an open question, and maybe some others might be able to comment more knowledgeably on that. But that may be a factor that adds some wrinkles to the types of cases we see. Washington State has currently not put in any liability limitations, but obviously we have an upcoming legislative session that that likely will be a topic raised.
That's very interesting. Thank you, Karl. I think from the federal government perspective, just a couple of quick observations. The first, of course, is that notwithstanding the fact that there are trillions of dollars out there in federal government money providing support to a wide variety of industries and kinds of businesses, there is a lot of oversight in this area. Of course, Congress structured into the statute a fair amount of oversight itself. There's also the Pandemic Response Accountability Committee, known as the PRAC, which is comprised of inspectors general who have particularly relevant practices in areas related to these stimulus programs. There's a special inspector general for pandemic recovery who is specifically focusing on and designated to look into these kinds of funds and give reports to Congress. And then, of course, the agencies themselves are really policing it. I think the other point to keep in mind regarding these kinds of funds is that I think from the government perspective, we're not thinking that these are going to really be aggressive new theories of liability or sort of new kinds of False Claims Act cases. I think the expectation is that with the kinds of things Karl has described and others may touch on, what we're really looking at are cases involving ineligibility on the front end of the program. Was the person or entity who received the funds entitled to them in the first instance? Or perhaps the funds were misused and not used as they were designated to be or supposed to be by law. There may be false statements in the course of performance in some way that affects whether or not there's a potential False Claims Act case. And of course, there's government procurement of goods and services and healthcare providers who were providing potentially unnecessary or substandard services, as Karl sort of talked about. But on the overlay to sort of these legal issues that I think many of us in this area expect to come up, there's sort of an interesting role that Karl touched on a little bit of the role and timing of agency guidance and the agency information that has come out in the wake of a lot of these new programs. And I thought maybe, Laura, you can talk a little bit about your view about how that may impact enforcement and the kinds of information and questions you're getting from your clients in this area.
Sure. Thanks, Jamie. I would say tracking the evolving agency guidance is really not for the faint of heart. And I don't mean that as a knock on the government necessarily. The money had to go out quickly, right? It was an emergency situation. I think what's most difficult, and I'll use PPP as an example, but I think what's most difficult is measuring certain certifications in hindsight. So particularly the necessity requirement for PPP PPP funds, right? Certain decisions had to be made at the moment at which the funds were applied for. And I think the government recognized, ooh, there's a big gap there. So in late April, they provided what I called this, no questions asked off-ramp, right? The safe harbor. You can give it, if you messed up, you made the wrong call, you can give it all back, no questions asked. That came really, really close on the heels of the program opening up in April, right? And so now what I would flag is sort of this questionnaire on necessity that has come out. It's open for comment now. So as a defense counsel, I'm worried about the notion of, so if your answers differ today in December, than they would have in April, which of course they will, because no one could predict where this was headed and how long a global pandemic was going to last, right? I think it really, really complicates the good faith certifications, which to your point will be the basis for False Claims Act cases, right? That's an easy touch. And the other comment I'll make about enforcement in this space, just because I think it came out late last night, and it's, I wouldn't encourage Relators Counsel to go here, but in the SBA did not appeal the decision that they be directed to give over a massive amount of data. If the post is correct, and I think the link in the Wall Street Journal is actually live and would take you to the data. There's a lot of zip files, a tremendous amount of time, depending on how fast your computer is to get it to download. But if the post is correct in their assertion that fewer than 5% of recipients received more than half of the funding, which is their headline stat, right? You can see that Zoom is happening by Relators Counsel circling, not that they're sharks, but it's all circling, it's all happening, right? And boom. But I get it, right? They're going to follow the money. And if that much money went to 5% of the applicants, I think in next year's ABA panel, the year after that and the year after that, we're going to be having harder, more in-depth conversations about the issues that you've flagged.
I think Tejinder is going to get a chance to test his theory of opinion falsity on the necessity standard when people sign up for those loans.
Yep.
Yeah, that's going to be fun. I mean, look, anytime the government puts out like a couple $1 trillion, like not all of that got stolen, right? But like some billions and billions got stolen. And just from my perspective, like I'm not greedy. If I recover just like $1 billion or $2 billion of that, I'm feeling like I did okay. So yeah, we're looking, we're looking pretty hard.
So I think it won't come as a surprise to anybody that this is an area that, in addition to Relators Counsel, the government, of course, is very mindful of and interested in. Because we have experience telling us that when there's a lot of money involved, there's always the potential for fraud, but also because these are our government programs, and our job and our duty is to police and ensure that the right people get the money. And I think the important takeaway I have for this, for the Laura and Davids of the world who are worried about the government, is I think that I would hope that a lot of industry and entities out there want these protections to be in place, want the law to be enforced the correct way, because the money is supposed to help the people who Congress thought should get the help. And there are guardrails and ways that this was supposed to be implemented. And if somebody's cheating, what it means is in this very limited pot of money, it's very limited in the grand scheme of things, somebody who maybe needed the money didn't get it. And now that we're on the cusp of yet another potential package maybe coming, you sort of have those same battles where every time $1 is going to somebody who didn't qualify or who maybe didn't meet the standards, you potentially have $1 lost to a company that is going to have to shut its doors because it needed the money and it didn't get it. So it's an important area for folks to keep in mind. And I think everybody is right. It will be an interesting thing for us to get to talk about next year, I think, on this. So I think we have time for one more topic. So let's advance our slide to see if we can talk a little bit about False Claims Act cooperation, which is not quite so much a legal development, but is an area that tends to generate some interest and discussion, particularly in light of the fact that the Civil Division issued a policy not long ago addressing the way that it will look at that kind of an issue in the context of resolving False Claims Act cases. So before we jump to that, I thought it would be interesting for folks to hear from Karl a little bit about how states evaluate this cooperation issue, and in particular, whether or not states have policies in place that deal with cooperation in ways similar to the way the federal government has.
Sure. A lot of it basically follows or is kind of derivative to the DOJ policies. Basically, a cooperating defendant is going to be recognized by the states when that occurs. Because we generally do our lion's share of our QTAM cases alongside U.S. attorneys' offices, whether or not a state has a formal policy, they're likely going to be giving the same consideration and credit considerations to a defendant. In state-only cases, the cooperation may arise more in the cases of co-defendants seeking to improve their own situation, which is a pretty common type of scenario in that type of case, or in a state-only case. And clearly they're going to be given consideration in that regard, and that may be at the time of settlement discussions that really comes into play. Regarding states having formal policies, I'm not aware of states having formal policies regarding cooperation and credit, such as the policies you mentioned in the introduction. Because there is that close tie with our involvement in cases involving the U.S. Attorney's Office and DOJ, the credit that is considered or applied there would basically apply across the state portion of the cases as well. The Medicaid cases are we can tend to focus on the Medicaid cases because that's our wheelhouse, but still the federal involvement in the Medicare and also in some of the Medicaid issues potentially, that's going to apply across the state portions of the cases as well. So short answer is not aware of very formal policies, but consideration given, especially in those cases where there's a global case involving the federal and state governments.
Thank you. I think that's interesting for folks to hear about the way that the states will evaluate those kinds of cooperation considerations on their own, and also in particular when they're handling them with the federal government in Medicaid cases. So from the federal government perspective, of course, there is a policy the Assistant Attorney General for the Civil Division issued earlier this year. And I think it won't come as any surprise to folks the kinds of things that are discussed in there. Generally speaking, responding to a subpoena or just sort of responding to the government's requests really is insufficient. Just not being difficult does not count as cooperation. Instead, I think the expectation that comes through with the Justice Manual, it's now codified in the Justice Manual, is that really you're going above and beyond in some respect. You are providing the government with some information that the government doesn't have, didn't know about, doesn't easily have access to, cannot itself generate, that you are going above and beyond what normally would occur in the context of responding to a government investigation. And some of the other things that are often considered are identifying potentially responsible individuals, which the government continues to have a focus on. And certain remedial measures also can be a factor for evaluating from the government's perspective the way to consider cooperation. And of course, in addition to receiving potentially a decrease in the potential multiple to be applied in a case, the government may publicly acknowledge the cooperation by the entity or the individual in its press releases or other kinds of public statements, which I think, and based on my experience, matters sometimes to folks. They want that out there because they want to be seen as good corporate citizens. I think that's from a policy perspective. I think I would also just give a plug from a practical perspective, which has been sort of my longstanding wish and practice, which I try to emphasize whenever I am invited on one of these panels, is that I think that as a practical matter, it usually is in the defense interest to cooperate with the government. I really do believe that by moving an investigation along and sharing information with the government, you're not working at cross purposes. And in fact, I think that you often have a larger role in shaping the government's investigation, shaping the course and nature of settlement discussions than you might realize when you're actually a participant in the process instead of being an obstacle to letting the government sort out how it would like to deal with a matter. So I think from a practical perspective, this is a policy that now is memorialized, but is one that I think many of us have adhered to for a long time as being a very effective way at potentially reaching a resolution in a case that I think is very encouraging. I think our last question, maybe Laura, if we have time for here, is this cooperation issue is a conundrum for defense lawyers, I think, from time to time, and I think folks would be interested to hear from you. How do you counsel a client in terms of whether to do this above and beyond? How do you decide when to pursue a cooperation credit?
Yep, and I know we're at time, so I'll be brief. But here's the deal. I think I try never to be an obstacle. I think you're right in theory about once you're in the soup, you've got to try to work hard to get to a resolution. I think the hardest place as defense counsel on when to advise is at time zero, when there is no key tam. You've discovered an issue, you've discovered a contractual issue, you've discovered an overpayment, and based on the policy which sets the floor, which basically says at a minimum the government gets singles, right? So maybe not doubles, which you would settle for, and I often have a hard time distinguishing to the advice to the client that when the client says, well, what's the difference between this and voluntary repayment? If it really was a color outside the lines, if it really was a contractual screw up. And I think the concern, and perhaps I'll put a plug in for maybe more detail in those press releases, if you ever when you give credit for it, is one of the most recent ones, press releases, it's Cognosante, if I'm saying that correctly, but that they brought in contractual they brought them to the United States, contractual violations, and resolved the settlement, to which a lot of my clients would say, yeah, there's a voluntary repayment program. I could have walked that money back in and reached a similar result. So I recognize there's greater coverage in a False Claims Act release, but sometimes that's hard when clients are making risk-based decisions. So thank you, Jamie.
Sure, thank you. Go ahead, David.
If there's a minute,
Yes.
can I add something about cooperation when there is a qui tam?
Sure.
So I share your view that it's in the company's interest, and most government contractors who view themselves as a partner with the government want to cooperate with the Justice Department and recognize that requires meaningful information, not just not saying no. The tension when we know that there's a qui tam and you're in the midst of making an intervention decision is what to do about requests from the government that require new analysis and work product, knowing that you could decline the case based on the investigation, and the first discovery request I get from Tejinder is, give me everything you gave DOJ. And that creates real tension for a company that knows that it may have to litigate this case, wants to do what it can to enable DOJ to make a well-informed decision, but also has to worry about its litigation position. And, protective orders or protective agreements, when the government will agree to it, can solve that to some extent. But it is a challenge in every case, and my clients are all misunderstood and wrongly accused, so they have to deal with these issues.
Thank you very much, David. You get the last word.
We don't have an official policy, but you can cooperate with me too. I would love to hear you just tell me everything. And, if you want, you can even hire me to be your lawyer. That'll be a lot of fun.
So thank you all very much today. That's all the time that we have. But before I want to leave, I would like to thank the American Bar Association, of course, for inviting us for today's panel. My understanding is that the next session will start in 15 minutes on damages and penalties. Thank you.